So today I wanted to talk about Kendra's Law, which is New York's version of assisted outpatient treatment. So Kendra's Law was established in 1999, provides outpatient treatment for individuals suffering from serious mental illness who are determined unlikely to survive in the community without supervision or are deemed an imminent threat to others. The law establishes a procedure for obtaining court orders for certain individuals with mental illness to receive and accept the outpatient treatment. The process begins with a petition and consists of a written treatment plan prepared by a physician who has examined the individual. Following the petition and the treatment plan, a hearing to include the examining physician and the person in question of the treatment takes place at the designated court. If the court determines that the individual meets the criteria for treatment, an order is issued to the Director of Community Services, or the DCS, who oversees the mental health program of the county in which the petition takes place. The court orders will require the director to provide or arrange for those services described in the written treatment plan that the court finds necessary. The initial order is effective for up to 6 months and can be extended for additional periods of up to 1 year if necessary. The law also establishes a procedure for evaluation in cases where the individual fails to comply with the ordered treatment and may pose a risk of harm. The Office of Mental Health is required to designate program coordinators who are responsible for monitoring and overseeing the AOT programs. County directors of community services are required to operate the AOT programs either separately or jointly with other counties. The directors of local assisted AOT programs report to the program coordinators regarding the operation of those AOT programs, and they also supply the program coordinators with information on every AOT treatment order. The Commissioner of Mental Health must approve all AOT orders before they are enacted. As I mentioned, New York State's version of AOT is known as Kendra's Law, which was named after Kendra Webdale, a New York City resident who was pushed to her death in front of a subway train in 1999 by Andrew Goldstein, a man with untreated schizophrenia. After the passage of Kendra's Law, New York State became one of 40 other states that actively provided AOT programs. As of 2017, 46 states have enacted AOT legislation. Prior to Kendra's Law, New York State had piloted a program at Bellevue Hospital called the Bellevue Pilot Program, which required individuals to fully meet 9 criteria in order to be considered for AOT. Despite evidence that the Bellevue Pilot Program neglected to make a significant difference, New York State decided to expedite the implementation of Kendra's Law immediately following her death, and it determined that only 7 criteria must be fully met. Critics argued that the lack of available treatment contributed to Kendra's death rather than the need for involuntary commitment, as Mr. Goldstein had sought commitment or supervised living no fewer than 13 times. Each time, he was discharged or denied help due to a lack of funding. Unlike the pilot program, Kendra's Law requires lower standards for involuntary commitment. So AOT is ultimately an attempt to address this revolving door patients that do not adhere to treatment measures following release from a hospital, but then subsequently decompensate and require rehospitalization. So who exactly can request AOT? A request for AOT must be filed as a petition in the Supreme or County Court where the person alleged to be mentally ill and in need of AOT is present or is believed to be present. For those who can request AOT, that includes an adult 18 years or older, roommate of the person, a parent, spouse, adult child, or adult sibling of the person, the director of a hospital where the person is hospitalized, the director of a public or charitable organization, agency, or home that provides mental health services to the person or in whose institution the person resides, a qualified psychiatrist who is either treating the person or supervising the treatment of the person for mental illness, a licensed psychologist or licensed social worker who is treating the person for mental illness, The Director of Community Services or Social Services official of the city or county where the person is present or is reasonably believed to be present, or a parole officer or probation officer assigned to supervise the person. In order for a person to be subject to AOT, the court must determine that the subject of the petition meets all of the following criteria: is at least 18 years old, is suffering from a mental illness, is unlikely to survive safely in the community without supervision, and that is based on a clinical determination, has a history of lack of compliance with treatment for mental illness that has, prior to the filling of the petition, at least twice within the last 36 months, been a significant factor in necessitating hospitalization in a hospital or receipt of services in a forensic or other mental health unit of a correctional facility or a local correctional facility, not including any current period or period ending within the last 6 months during which the person was or is hospitalized or incarcerated, or prior to the filing of the petition resulted in one or more acts of serious violent behavior towards theirself or others, or threats of or attempts at serious physical harm to self or others within the last 48 months, not including any period or period ending within the last 6 months in which the person was or is hospitalized or incarcerated, and is, as a result of his or her mental illness, unlikely to voluntarily participate in the outpatient treatment that would enable him or her to live safely in the community. In view of his or her treatment history and current behavior, is in need of assisted outpatient treatment in order to prevent a relapse or a deterioration, which would be likely to result in harm to the person or others as determined in 9.01 of this article, and is likely to benefit from outpatient treatment. AOT must be the least restrictive means of treatment in order for a court to issue an AOT order. So the petition process has 5 steps, ultimately. In the process of the petition must determine that the subject of the petition meets, again, full criteria for AOT as supported by the examining physician, with the exam to be conducted within 10 days of the filed petition. If the physician is unable to gain consent from the subject for examination within 10 days, the physician must document all unsuccessful attempts and still make the case that AOT is still warranted. In certain cases, the court may require that the subject submit to an examination. If the person refuses and the court finds reasonable cause to believe the allegations in the petition are true, the court may order that police officers take the person into custody for transport to a hospital for examination by a physician for up to at least 24 hours. As for the service of the notice and petition, the petition must be served to the person against whom the petition is being filed, the subject's nearest relative, the mental hygiene legal services, the AOT program coordinator as appointed by OMH, and any health care agent as designated by the subject and the designated county AOT program director. As for the written treatment plan, the examining physician, as appointed by the DCS, prepares the treatment plan submitted to the court. The examining physician must permit the person, his or her treating physician, and, if requested by the person, a relative, close friend, or other concerned individual to actively participate in the development of the treatment plan. Case management, assertive community treatment, or ACT services, and other services as deemed appropriate for treatment must be included in the treatment plan as a means of care and service coordination. if substance abuse counseling is included in the plan, the person may be subject to toxicology screening. However, the physician must present sufficient evidence that 1. The person has a history of alcohol or substance abuse that is clinically related to his or her mental illness, and 2. Testing is necessary to prevent a relapse or deterioration, which would likely result in serious harm to the person or others. A physician must certify to the fact that the suggested treatment plan is the least restricted method of treatment. If the treatment plan includes a recommendation for medication, the testimony must include the types or classes of medication recommended, the beneficial and detrimental physical and mental effects of the medication, and whether the medication should be self-administered or administered by authorized professionals. After the written treatment plan is officially submitted, we have the court hearing. The court must schedule a hearing within 3 days of receipt of the petition. However, if the court determines there is good cause, the hearing may be adjourned. The examining physician must testify at the hearing and must state the facts and rationale supporting the need for AOT, as well as the conclusion that such treatment is, again, the least restrictive alternative for treatment. The subject of the petition has the right to legal representation by mental hygiene legal services or by another counsel at the subject's expense at all stages of the proceeding. The person must also testify, call witnesses, and examine any adverse witnesses. The written treatment plan must be presented to the court before issuance of an AOT order. If the petitioner is the Director of Community Services operating an AOT program, the treatment plan is required by the court by the date of the hearing. Finally, we have the disposition of the proceeding. If the court determines that full criteria for AOT are not met, the court will dismiss the petition. However, if full criteria is met and the written treatment plan has been determined appropriate, the subject will be ordered to receive and comply with AOT. The initial AOT order may designate a subject to comply with AOT for up to at least 6 months. The court cannot require treatment that is not ordered by the examining physician as specified within the written treatment plan that was submitted during the hearing. If deemed necessary, following another hearing to include physician exam and an updated written treatment plan, the initial AOT order can be extended for an additional period of up to 1 year if deemed necessary. If a subject has failed or refused to comply with the treatment ordered by the court, a physician may determine that the subject is in need of involuntary admission to a hospital and will then request a designee to transport the subject under 937 status. Typically, police officers will be responsible for taking the subject into custody and transporting the subject to the hospital for evaluation. EMS and crisis services teams are authorized to issue a 937 but cannot legally provide transportation of the subject. The subject may be hospitalized for up to 72 hours for observation and treatment. However, after the 72 hours, a qualifying physician will determine whether further treatment is needed, warranting extended involuntary status. If the subject does not meet criteria for involuntary admission within the initial 72 hours, the subject must be released. A complementary part of Kendra's law is the medication grant program. This legislation provides grants for the cost of medications and other services needed to prescribe and administer medication for individuals with a mental illness who leave the local jails, state prisons, or hospitals and have applied for Medicaid. Currently, the way the system works, many individuals who leave these jails, prisons, and hospitals receive only limited supplies of medication until they actually qualify for Medicaid. The medication grant program, however, provides funding to counties to pay for the individual's mental health medications and services, again, related to providing medication until they are actually approved for Medicaid. However, it is important to note that the population targeted by this medication grant program may be quite different from the group of individuals who qualify for actual assisted outpatient treatment. While there will be likely to be some overlap, the eligibility requirements for individuals under the grant program are different from the eligibility criteria for assisted outpatient treatment. This law ensures that individuals who are released to the community from hospitals or correctional facilities, again, have immediate access to prescribed psychotropic medications. The grant program is administered and funded by OMH until determination of Medicaid or medical assistance eligibility. The program may also provide funding to assist in services pertaining to the written treatment plan as pertinent to the AOT order. Furthermore, the grant may also collaborate with local correctional facilities in an effort to improve coordination between medicated individuals and prescribers, with additional assistance in helping individuals apply for the medical assistance and/or other financial assistance. AOT orders must include the following: case management services and assertive community treatment team services, or again, the ACT services. Orders may also include medication, blood or urinalysis tests to determine compliance with prescribed medications, individual or group therapy, day or partial day programs, educational and vocational training, supervised living, alcohol or substance abuse treatment, alcohol and or substance abuse testing for those with a history of abuse and for whom such testing is necessary to, as previously mentioned, prevent a deterioration of their condition. And those are court orders for the tests, subject to be reviewed every 6 months. And any other services provided to prescribed to treat the person's mental illness and to assist the person in living and functioning in the community, or to help prevent a relapse or deterioration that may reasonably be predicted to result in suicide or the need for hospitalization. This is going to be a heavy slide as we consider some of the trauma-informed and human rights considerations. In terms of the potential for trauma and human rights violations, there are several issues that we need to consider. The law appears to have both therapeutic and anti-therapeutic aspects, and that it may lead some persons with mental illness to seek needed treatment that they might not otherwise receive. It is a less restrictive alternative to inpatient hospitalization, with the potential to increase adherence to treatment and give the person a sense of control over their own treatment. Some argue that AOT can actually, quote-unquote, free subjects by liberating them from their illnesses due to lack of insight into mental health and treatment needs. Furthermore, the subject will be less likely to be restricted, again, within an inpatient setting, assuming compliance with an AOT order. On the other hand, some argue that while AOT cannot forcibly administer medication, subjects are essentially coerced into accepting treatment. While the subject technically has a choice whether or not they submit to treatment, they are still restricted in their liberties as they must face consequences of inpatient hospitalization or incarceration, both highly restrictive means of treatment. By subjecting an individual who refuses treatment to serious consequences, the law infringes on an individual's right to determine his own course of treatment, particularly the right to refuse medication. It has also been argued that language surrounding AOT criteria is too broad, allowing for basically any individual with a recent history of treatment non-adherence to qualify for mandated treatment, regardless of whether they actually pose a threat to public health. Critics also argue for the potential to develop neuroleptic, malignant syndrome, or some other potentially fatal antipsychotic drug side effect because of a misdiagnosis or an error in prescription or medication dispensation. While the legislation does not have the authority to forcefully administer a medication, there will again be consequences for any subject that refuses medication, again including inpatient hospitalization or incarceration, depending on the circumstances that led to the original AOT order. Law experts continue to argue that the law violates the physician-patient privilege and that the treating physicians are required to testify and provide confidential information at the AOT hearings. Suggested alternatives include allowing court-ordered physicians to evaluate an individual rather than the treating physician. However, that leaves the potential to neglect information pertaining to patient history and patterns of behavior of which only the treating physician may be aware. The treating physician's familiarity with the patient would likely and adequately demonstrate the fulfillment of full AOT criteria over possibly a court-ordered physician. Courts have continuously maintained that Kendra's law is constitutional and is not a direct violation of a person's right to autonomy when compared with safety of the general public, particularly as AOT is generally deemed the least restrictive method of treatment. Yet, the legislation remains under strict scrutiny throughout each process of renewal. However, New York State continues to, again, justify restrictions on the individual's liberty, assuming that only the appropriate candidates for AOT come within the reach of the statute. However, as previously mentioned, some of the language is so broad that patients who may not pose a threat are actually qualifying for AOT. Subjects of a petition have the right to counsel and should be provided with appropriate and sufficient representation by mental health legal services. However, there is no definite time frame of when counsel begins for the subject. If counsel is delayed, lawyers do not have adequate time to prepare a case, actually meet the client that they will be representing, or review the written treatment plan. Ultimately, the law both enhances and violates human rights in that the safety of society is enhanced while the rights of individuals suffering from mental illness are violated. In an effort to reduce the amount of individuals subject to AOT orders, an overhaul of services should be considered, including intensive case management, funding for community resources and programs, psychoeducation, and improvement of policies and procedures that contribute to pervasive mental health, including housing, transportation, and other financial support services. As for Erie County specifically, the Erie County Department of Mental Health has designated community-based care coordination teams, such as programs of assertive community treatment or ACT, or intensive case management to coordinate and or deliver AOT services consistent with an individualized services plan. If you have any other questions, if you're not directly involved in communicating AOT orders, you can contact the Erie County Department of Mental Health's AOT program at 858-7059. Appropriate staff will respond to your concerns and questions. They'll gather some information about the referral, and then they'll commence a screening that will determine eligibility and refer to one of the care coordinator teams. So Erie County has several AOT care coordination programs, essentially assertive community treatment programs that they use. There is one operated by the Buffalo Psych Center. However, they only accept referrals from BPC inpatient, outpatient, and BPC housing. There is one operated by CSDD, but the referral, individuals referred must meet criteria for developmental disability. There is a program through Best Self, and Spectrum Human Services also has a program. Buffalo Federation of Neighborhood Centers has an intensive case management program called New Options that may be an available option. And Spectrum also has Spectrum Care Coordination Program that may be available as well. So essentially, these programs will assess the consumer's current status and needs, develop individual service plans. They will monitor and reassess needs on an ongoing basis and respond to crisis situations. Staff work with an array of community organizations and are typically on call 24/7. Some additional consumer services allow consumers to have the opportunity to access legal representation throughout their involvement with the AOT program, again, from mental hygiene legal services. In order to ensure personal choices regarding mental and physical care, anybody can document preferences in an advance directive in the instance that they become incapable of making treatment decisions. For more information about advance directives, you can call the Western New York Independent Living Project or Mental Hygiene Legal Services. Programs may also enlist the help of a peer, in which case you can contact the intake coordinator at Western New York Independent Living Project. And for more information or information about self-help groups, you can contact the Action for Mental Health or the Mental Health Association. ACT services may sometimes also include, of course, clinical treatment of mental illness and substance abuse, but also assistance with family life and social relationships, service planning and coordination, problem-solving skills, daily activity skills, relapse prevention, medication management, vocational and educational assistance, healthcare education and linkage, money management and entitlement assistance, housing assistance, and peer support assistance. As we know, programs are constantly evolving. They're apt to change, so I encourage you to contact the Erie County Assisted Outpatient Treatment Program if you have any questions or concerns about referring anybody or about available services. The contact information is presented on the following slide. Finally, I wanted to go through and address some questions that you may still have, or things that weren't maybe addressed in previous slides. So whom should I contact if I think someone needs assistance through AOT? I would contact your county mental health director. County mental health directors are responsible for operating the county's AOT program, and they can help you determine whether or not the person meets the criteria for AOT. And they may also be aware of other available services if AOT is not appropriate for the individual. What happens if the person does not comply with the terms of the court order? If a physician determines that the person has failed to comply with some aspects of the AOT order and also determines that the person may need involuntary admission to the hospital, the physician may recommend and the county director order the person to be transported to a hospital and retained for up to 72 hours to determine if inpatient care and treatment are necessary. Any refusal of the person to take prescribed medication or the failure of a test to determine either medication compliance or alcohol or drug use may be considered by the physician in reaching the clinical determination regarding involuntary admission. Any decision to retain the person beyond the initial 72 hours must be in accordance with the procedures for involuntary admission set forth in mental hygiene law. How long does the person remain in the AOT program? The initial court order may be granted for up to 6 months. The order then can be extended for successive periods of up to 1 year for as long as it is deemed to be necessary and beneficial for the individual. Once an AOT order is expired and not renewed, the individual should continue to receive the same services he or she was receiving while under the order. What is the role of the healthcare proxies? If an individual has executed a healthcare proxy, any directors included in such proxy shall be taken into account by the court in determining the written treatment plan. However, nothing precludes a person with a healthcare proxy from being eligible for AOT. Can the county or provider of services bill private insurance for court-ordered services, and do they have to pay? Insurance companies may be billed for services. However, the insurance company is not mandated to pay for court-ordered services. It must be a reimbursable service within that particular insurance company's policy for payment to be made. Must an individual have an AOT order to be eligible for the medication grant program? No. The medication grant program is intended for those individuals being released or discharged from jail, prison, and or hospitals who require medication to treat mental illness and for whom a Medicaid application is still being processed. AOT status is irrelevant with regard to eligibility for the grant program. Can the medication grant program cover medication for non-insured AOT cases? Yes. If the client meets the requirements for the grant program, they will be covered. If you were to refer to OMH website, they do have a brochure available that has additional information regarding the medication grant program that you can access. Who can renew a court order? If the Director of Community Services determines that a person requires further AOT treatment, the Director shall apply within 30 days prior to the expiration of the initial order for a subsequent order for a period not to exceed 1 year. If the authorized petitioner for the initial order was either the subject's family or roommate, and if he or she retains at the original status with respect to the subject, then that petitioner may pursue a renewal order for a period not to exceed 1 year. Is the renewal procedure any different? The procedure for obtaining a renewal is the same as for an initial order, except the subject does not have to meet either the 36-month or 48-month criteria regarding previous hospitalizations or acts of violence. If a county wants to do a renewal and the patient is hospitalized, are there any provisions for a non-privileged MD to examine the individual in the hospital? No. The county would have to make arrangements with the treating hospital to allow a designated physician to perform the evaluation. Can an order keep being renewed? Yes. If the individual continues to meet the criteria and is clinically determined that he or she is likely to benefit from the order, the AOT order will continue to be renewed. So I hope that I was able to explain a little bit about Kendra's law, what comes along with it, what the criteria is in the process for applying for AOT, I encourage you to refer to the resources available in the next couple of slides if you are interested in learning more information. I would also appreciate it if you would leave feedback for me about the presentation. If you have any further questions, anything that you think should be included, or if you have experience completing AOT orders, I would be interested in hearing from you. If you have anything that contradicts the information that I presented or anything to add to it, of course. So thank you for your time. And again, I hope that I was able to provide some valuable information.